Vietnam continues to attract foreign investors seeking growth opportunities through mergers and acquisitions. However, beneath the promise of high returns lie legal risks that can derail transactions or lead to costly consequences post-closing. If you are a foreign investor planning to acquire a Vietnamese company, you need to be aware of the unique legal landscape and the risks that often go unnoticed. In this video, we will cover the top 7 legal risks in Vietnam's M&A transactions and explain how to identify and manage them before it is too late. Risk 1. Invalid or incomplete corporate documentation. One of the most common legal risks in Vietnam M&A deals is incomplete or invalid corporate documentation. Many target companies operate with outdated charters, missing shareholder resolutions, or unregistered capital contributions. This creates uncertainty over the company's legal status and raises questions about the validity of past decisions and ownership. During legal due diligence, it is critical to verify the company's charter, amendments, corporate registration, and capital structure to ensure legal integrity before acquisition. Risk 2. Unlicensed or improperly licensed business activities. In Vietnam, business activities must be declared and registered with the authorities. Many companies operate outside the scope of their licensed activities or fail to obtain the required sub-licenses. For example, a logistics company may lack warehouse permits or a manufacturer may miss environmental certifications. Foreign investors acquiring such companies may inherit regulatory violations and risk suspension of operations. Legal due diligence must confirm that all core business activities are properly licensed and compliant with Vietnamese law. Risk 3. Non-transferable or restricted contracts. A key value driver in M&A transactions is the continuity of commercial relationships. However, many contracts in Vietnam contain clauses that restrict assignment or include automatic termination upon change of control. These clauses are particularly problematic in asset deals, where contracts must be transferred to the buyer's entity. If a material contract cannot be assigned or must be renegotiated, it can delay closing or reduce the commercial value of the transaction. Legal review of top-tier contracts is essential to uncover and manage these risks early. Risk 4. Land use rights and real estate issues. In Vietnam, companies cannot own land but may hold land use rights. These rights must be registered, transferable, and free of encumbrances. However, many businesses lease land from third parties without proper documentation or hold expired land use certificates. Investors acquiring such companies may face legal disputes or operational interruptions related to site control. Legal due diligence should confirm land title, lease validity, permitted use, and whether transfer is legally allowed. Risk 5. Unresolved litigation and regulatory investigations. Because Vietnam lacks a centralized litigation database, pending lawsuits or investigations are often not disclosed unless specifically requested. A target company may be facing tax audits, labor claims, environmental inspections, or contractual disputes that could impact future operations. If litigation is discovered after closing, the investor may have little recourse. Legal due diligence should include thorough searches, written confirmations from the company, and warranties in the transaction documents to protect the buyer's position. Risk 6. Labor law violations and employment risks. Vietnam has strict labor regulations, and violations can lead to fines, disputes, or loss of social insurance benefits for employees. Common issues include improperly signed employment contracts, failure to register internal labor rules, or underpayment of Social Security. Investors acquiring a company with ongoing labor violations may be liable for back payments, penalties, or reputational harm. It is critical to review HR policies, management contracts, and compliance with the labor code as part of the legal due diligence. Risk 7. Ownership disputes or undisclosed shareholders. In some Vietnamese companies, shareholder records are poorly maintained or informal capital contributions have been made without proper registration. This creates risk of ownership disputes, especially in family-owned businesses or joint ventures. In certain cases, hidden stakeholders may challenge the legality of a sale post-closing. Investors must verify the official shareholder list, confirm that all contributions are legally documented, and review past equity transactions for compliance with investment laws. While these risks are real, they are manageable with the right legal strategy. Legal due diligence is the investor's primary tool to detect, evaluate, and mitigate legal exposure. Once identified, risks can be addressed through transaction structuring, price adjustments, indemnity clauses, pre-closing remediation, or post-closing conditions. A well-drafted sale and purchase agreement with clearly defined representations, warranties, and dispute resolution clauses is essential to protect the buyer's interests. At LTS Law, we help foreign investors uncover and neutralize legal risks in Vietnamese M&A deals. Our due diligence process is comprehensive, fast, and customized to your transaction type. We go beyond listing issues. We provide practical solutions and help you negotiate protections. From red flag reporting to closing support, we ensure your investment is built on solid legal ground. Before you close your next M&A deal in Vietnam, make sure you are not buying into unknown legal problems. Let LTS Law help you identify and manage critical legal risks. Visit lts.com.vn or contact our team to schedule a consultation. Make your next deal a success, because knowing the risks is how you reduce them.